Joining us, and our guest now, Christopher Green, law professor, University of Mississippi Law School. Good to see you, Professor.
Good to see you again.
Well, the old Supreme Court, they've been busy some more, have they not, dealing with this Texas immigration issue? Honestly, my head is spinning a bit on that one. Can you break that down? It looks like we got a ruling, and then in less than 24 hours, the whole thing got overturned or reversed. Explain what happened here.
Yeah, it's a fast-moving situation, and there's a lot of there's been a lot of inquiry in the last several years just about the manner in which the Supreme Court deals with these fast-moving situations. So they actually haven't. I gotta check the Supreme Court's website to see what they've done lately. But they basically, the Fifth Circuit, they've got a couple of things they can do when they're so we got stuff that happens at the trial court, and then you've got stuff pending appeal. And the Fifth Circuit, sometimes they say, well, we have an administrative stay, just like while we're reading the papers. That's not a stay pending appeal. And then they can have a stay pending appeal. And then there's a question which Justice Barrett raised in an opinion yesterday about whether the Supreme Court can even review, or maybe whether they should review, the mere administrative stay, rather, as opposed to the stay pending the appeal. So the stay kind of pending reading of the briefs. They said they would not reverse, but they told the Fifth Circuit, you better rule on this stay pending appeal pretty quick. And then the Fifth Circuit sent out a letter to parties saying, okay, let's show up tomorrow, and we'll have a hearing on this stay pending appeal. So they, and again, I guess I'm clicking on. Okay, so the Supreme Court itself hasn't done anything additional on that, but it's a fast-moving situation, and it's kind of funny because the rules about how they deal with things in fast-moving situations, in theory, they should be able to do those kind of calmly, and take several months to think like, well, how do we deal with emergencies? But when they don't have rules, they tend to kind of have to settle rules about emergencies in emergency situations themselves. So it really is kind of not ideal. But it's in part, it's the kind of non-ideal nature that you have with non-ideal situation they have with courts of our nature, where they wait until controversies arise before they resolve them. So how do you deal with emergencies? Well, wait till the emergency arrives. I'm not sure that's the best way to run a railroad. So sometimes some judges think, oh, well, I'll just sort of have an opinion at the ready to explain how I deal with emergency situations, and I'll just unveil it the next time we have an emergency. So that's, but it's an artifact of how we deal with how we dispense justice in a common law system. We wait for lawsuits.
So do I understand this correctly, that the same court ruled one way and then turned around and ruled another way? That I'm confused on sort of the chronology here.
Yeah, I'm probably with you there in terms of the confusion. So it's possible the Fifth Circuit, they had an administrative stay, or they refused it.
District Court in Austin issued an injunction, right? That's my understanding. And then the Fifth Circuit Court came out and halted the injunction, and then they came out and reversed that. Is that right?
Yeah. So I think they may have an administrative stay that then got changed in a different way in pending appeal.
Okay.
Yeah, I don't have as I should know. I mean, my goodness, I'm in the Fifth Circuit. I should have a better ability to figure out instantaneously what the Fifth Circuit's up to. But they may have changed their minds. The Fifth Circuit also they have a rule that stays pending appeal can actually be reconsidered by the entire 17 judges. Administrative stays can't. And there's actually disagreement among the circuits. Some circuits allow stays pending appeal to be taken to the en banc, the full court. In the Fifth Circuit's case, the 17. So it's there may have been some disagreement there or something like that. But I can't tell you the full deal with that.
And this deals with Texas essentially asserting its authority as a state to essentially implement some controls around immigration, right? And it's my understanding that the Austin judge said, well, we can't let you do that because then the other states may also come forward. And then all of a sudden, rather than the federal government, I guess, handling and managing this issue and patrolling and securing the border, now we got states involved in that. And there's sort of steps on the federal government. Is that kind of the essence of what this was about? It's my understanding is Texas said, we can't wait for the federal government anymore. They're not getting this done. These folks are invading our state, causing problems and harming our citizens and damaging our property. We got to take action because the federal government won't.
Yeah, so so Texas is saying so there's one issue, which is to what extent can states create their own law of immigration?
Okay.
So that's a question about whether certain regulations are preempted by federal regulation. There were some cases involving Arizona where they went ahead and said, okay, we're going to create some new rules about how immigration things are investigated.
Yeah.
Texas is not quite doing that. What they're doing is they're saying there is law about this issue created by the federal government. So we have federal law, but what we want to do is enforce federal law ourselves. So it's not so much a question of whether the states can create law, but whether they can come in and respond to the exercise of prosecutorial discretion by the feds. So there was a case last spring about whether they could sue the federal government and complain about the exercise of discretion, kind of big, huge exercises of discretion. And the court said some complicated things, but one of the things they said that some of the justices said emphatically is you can't complain about the lack of enforcement of the law against somebody else. That's not a legally cognizable injury. And that's the kind of thing that I've actually been complaining about that rule. So that's been the rule for 50 years, and they reaffirmed it. But there's some good arguments to revisit that. At any rate, this is okay. We're not going to sue to get the federal government to enforce federal law. So we're not creating new state law that we say applies. We're not trying to sue to get the federal government to enforce. We're just going ahead and enforcing it ourselves to some extent. Okay. And so there's a question essentially of one way to think of it is the exercise of prosecutorial discretion at the federal level. Does that have a sort of preemptive effect of state and local enforcement of federal law? And so the exact nature of this thing at the federal government, these exercises of discretion, is really, really important for understanding exactly what it's doing. So really all of this is just an artifact of the fact that Congress has not legislated on this really since 1986 in terms of the really key questions of what on earth we're doing with immigration. So because of that, you've got huge exercises of discretion, huge just sort of non-enforcement. You have just physical limitations on the ability to enforce. So it's all that non-enforcement, the huge prosecutorial discretion creates a lot of bizarre or strange legal conundrum. And all the emergency nature of it is just, well, that's just sort of what happens when you have fast moving litigation and fast moving emergencies. The COVID, we had piles and piles of cases, kind of emergencies within emergencies going on, and we have that again.
Okay, let's pivot. Let's talk about this appeal bond that the former President Donald Trump is searching for. It doesn't seem that any of the underwriters were willing to accept his assets as collateral for this, $454 million appeal bond. He says he doesn't have sufficient amount of cash. His lawyers do, at least, to meet that amount, to satisfy that amount. What's next? I mean, is it possible that the state of New York, via the Attorney General, starts seizing assets?
They could try. So this was years ago. Actually, I was don't want to tell anything too spicy about my own time working for the Fifth Circuit, but we had a case where so there's a bunch of rules about appeal. So one thing to remember: the lack of an appeal bond doesn't mean you can't appeal. It just means that whoever has the judgment can try to enforce it during the pendency. And if they go seize a bunch of assets and then Trump wins his appeal, well, they're going to have to return those assets. And there's a bunch of complicated questions about how exactly you return assets that you seize pending appeal. But you have a bunch of rules about like automatic stays while you're getting a bond. And so Trump has been trying to get the court to say you should exercise your discretion and just give me a stay, even though I didn't put up a bond. But New York, they could well come after his assets. I don't think it would be a great look. But
we got a break. If you can hang on there, Professor, I want to ask you about how the Eighth Amendment might figure in to this $454 million bond. If you can stay around.
Sure.
We got Christopher Green with us in the Element Wealth studio. We are visiting with law professor at Ole Miss Law School, Christopher Green. So, Professor, this $454 million, I mean, when you read the Eighth Amendment, it's pretty clear about excessive fines and cruel, unusual punishment. Seems like this would fit into the category of excessive fines imposed. What am I missing here?
Well, there are so you have a bunch of rules in the Constitution, a bunch of them in the Bill of Rights that are keyed to punishment. So you're not allowed to punish people in certain ways. So you can't have excessive fines; those are imposed as a criminal penalty generally. But then, and then cruel and unusual punishment use the word punishment. There are a whole bunch of doctrines about when other things that happen in the courts, let's call them, come so close to being punitive that they are subject to the same kinds of rules. Generally, so there's a rule, for instance, there's a constitutional law, some constitutional law about the size of punitive damages. But we don't have any con law to speak of on the size of civil damages. So, massive damages like, the Lowen Group, the mortuary situation we had 30 years ago. They just made a movie about. Those were some serious size compensatory damages that they were talking about, and just you would have to, in order to for Trump to win that this is a fine, an excessive fine, first he'd have to win that it's that's a fine. Okay, so arguing that it's the functional equivalent of the fine, sometimes those kinds of arguments work. They tend not to. So there hasn't been any push from the kind of business community, defense-oriented community to say, well, let's expand the punitive damages limits into just size of damages as a whole, because there's a heck of a lot more just excessive assessments of damages really than punitive damages. Generally, they've been pushing for things like, well, let's try to push those sorts of things into federal court more frequently. But it is, you kind of read through the Bill of Rights, and if you're really, really stingy about the word fine and the word punishment, you might say, yeah, there's not obviously anything here that we can really hang our hat on. Due process, is that, does depriving somebody of property without due process, does that mean depriving them of due property, of property unreasonably? Well, that's the kind of reasoning that gives us things like Roe v. Wade. That's the kind of thing that they used years and years ago to protect freedom of contract under the 14th Amendment. But it's, as a textual matter, it's pretty dicey. So fines is probably a lot closer. So trying to make that argument work is more likely to win.
Huh. Well, I hadn't thought about that. So what does he have a possible remedy, or not just Donald Trump, but in this case, just because it's $454 million? I mean, would it be possible, and would he have a chance at a case that asserts that this is excessive, this is a violation of his constitutional rights, and thus the court should reduce the amount?
Yeah, it's tough. I mean, there are a lot of discretionary powers of the court to delay enforcement of the bonds, or not enforcement of the bonds, but enforcement of the judgment. So, So certainly he's going to go to I don't know if he's going straight to the appellate division and then to the New York Court of Appeals or exactly what they're doing, but certainly the appellate folks in New York are going to be keeping an eye on this. One thing he could do, if he, suddenly if Mar-a-Lago, somehow gets, or whatever New York assets he's got suddenly get seized. One thing he could do is say, okay, well, appellate folks, please do this as expeditiously as you possibly can so that I can get my property back. And then, then there's going to be a whole bunch of questions about just what exactly you can do when you have your property seized and then presumably not taken care of as well as he would in the meantime. But it's a tough issue. I kind of hope that, as people start seeing this in, kind of really, really vivid terms with Trump, the people will start paying attention to just the general kind of huge imbalance of power that you get between prosecutors and criminal defendants. Just all the discretion we talked about, all this discretion in immigration law, just the ability to enforce or not enforce the law is a massive, massive prosecutorial power. Supreme Court had another case yesterday just about the New York Attorney General being kind of thuggish with respect to insurers of the NRA. And Andrew Cuomo said, basically in response to the lawsuit, said, yeah, you think we're trying to bankrupt the NRA? Yeah, let's make it a hashtag bankrupt the NRA. It's sort of like in Few Good Men, did I order the code red? Yeah, I ordered the code red. Yeah, of course I'm trying to bankrupt the NRA. Let's make it a hashtag. So
always good to talk to you, Professor. Yeah. Appreciate it, man. It's scary. I think this is an attack just not on Donald Trump, but on America. Appreciate it, Professor. Thank you.
Good to see you.
We're coming right back, folks.